The Rehoboth Beach Planning Commission meeting of October 11th, 2019 will come to order. It's 3:06. And would you take a roll, please?
Mr. Perry,
Here.
Hubbard,
Here.
Mr. Weber,
Here.
Mr. Strange.
Here.
Chair
Is here.
Ellen, myself, we have a quorum.
Okay. Jeffrey is in Mexico at a wedding of his family. And Joyce had something that was a
It
conflict.
was a conflict.
Verification of meeting notice. Ann?
The agenda was posted in City Hall on October 3rd and uploaded to the portal on the same date, and also sent out to the subscribers.
Okay, thank you. And I'm assuming that we do not have any minutes, is that correct? Is that correct? We gotta get you some help. Would that help? No answer. A little late, okay. I don't think we have any correspondence.
We meant to.
No old business, no new business, okay, and we have other business. 2020 Comprehensive Development Plan, just an update. I believe the mayor has scheduled a joint meeting between the commissioners, mayor and commissioners, and the planning commission for the 28th of this month. Not sure on the time. Is it 3 o'clock in the afternoon?
No, it's at
Or it's
1.
it's at
It's at
1.
1 o'clock.
It's at 1. And also on the agenda was a special meeting of the planning commission. I don't exactly know what that was about, but we'll figure that out.
That was an expectation.
Time out. Okay, time in.
That was just an expectation that, we could potentially
Okay.
have a meeting with the new
And that will be
members.
the data reveal meeting,
Yes, yeah,
okay?
But the joint meeting is at 1.
yes.
1 o'clock, yes. We have an opportunity, item B, an opportunity of a lifetime, okay, or at least of a 1-month lifetime. We need to elect a vice chair today, now, to replace Susan, who has gone on to bigger and better things. So normally we would go through a process, and we'll talk about the process a little later, but this is a 1-month opportunity. After 1 month, we will have a new planning commission, and that planning commission will, in turn, before the end of the year, hopefully long before the end of the year, will elect a set of officers to serve it for the next year. So I guess the easiest thing, is there anybody that would like to volunteer for a 1-month job as vice chair?
I'll volunteer.
You'll volunteer. Is there anybody else that would like to volunteer?
I don't know.
Okay, well, wait, no?
This is gonna be easy.
This is a fairly easy choice,
Like it's unanimous.
unless we all abstain.
Well, that's always a possibility,
That's
I
always a
suppose.
possibility.
Of course, then we would have a non-functioning planning commission.
We have a volunteer, self-nominated of Rick Perry to serve as vice chair.
I'd like to nominate Rick Perry as vice chair.
You would, okay, all right. Well, that makes it more official. Is there a second?
Second.
It's been proposed and seconded that Rick Perry serve as vice chair as a replacement for Susan Gay for 1 month at least. All in favor, say aye.
Aye.
Aye. Is there any opposed? You're it.
Thank you for your confidence for a 1-month job.
It's better than no months.
Yeah, that's true.
Okay. Rick has worked on a number of, had raised some issues relative to the rules of procedures and bylaws that haven't been edited for quite some time. And he did a couple of run-throughs and ended up with a final modifications. Unfortunately, we thought we had sent the red line version to everybody and posted it, but it was a previous copy. So if you want to take us down, this is going to be just a reading through.
Yeah,
This is
just
not going to be an election, or we're not going to vote on this, but it's just a reading to give us some thought. The new planning commission will have to deal with any changes and votes thereof. Okay, so I would summarize it by, some of it is just words to better define things. Probably the biggest one deals with how we nominate and elect officers. And there's one other conflict, and that was sort of a timing conflict, which got changed over the years. And it caused a conflict relative to, which was not, in fact, caused by the Planning Commission, but it was a conflict related to when we elected officers. And there have been occasions when the mayors, different mayors, did not make their appointments for new positions on the commissions until too late for us to elect in November and even in December. I mean, originally the document called for the end of November. And in fact, state law says we have to do it once a year. So December 31st is probably a logical date, although we could do it earlier, assuming that the nominations are made. But the problem was not really one of our making. It was due to the mayor not making appointments. Mayors not making appointments.
Yeah.
So, you want to run through some of these? I think there's a clean copy. There's an original copy of the bylaws and the red line copy, which Ann just gave to us.
Rick, can you, before you start, can you run quickly through the sequence of the documents that we have? There's, I guess, the original bylaws, and then there's an amended and restated bylaws,
Yes.
and then this is a red line to the amended and restated.
Yeah.
Yes, this is a red line of the amended and restated bylaws, which, is redlined against the original bylaws as they exist today.
Not against the original amended and restated document.
Well, they were amended over, the bylaws in effect currently were amended from time to time. The last time being, I believe, November of 2015. And so the red line version that you have is a red line against those bylaws as in effect as of November 15th, 2015. Okay. So.
Yeah, the other issue, by the way, was the meeting time issue. Over the years, we used to meet at 7 o'clock, then we met at 6 o'clock, and then we set some time limits for the last business that we would deal with. And so it's sort of out of kilter with what we're doing time-wise right now. So, you want to go ahead, Rick?
Sure. Originally, I started out in this process because of the discussion that we had regarding how we select nominees for officers and the timing. Once I dove into the bylaws, I realized that they really needed an overhaul. There were a lot of internal inconsistencies within the bylaws. There were provisions that I felt shouldn't be in the bylaws, but should be in the policies and procedures. There are inconsistencies between our bylaws and our city code as well as the state code. And so I've tried to, as best as possible, clear up those inconsistencies and where I thought it was necessary to provide clarifying language. I attempted to do that. And so you've got a pretty significant rewrite of the bylaws in essence. I've gotten some comments already from some of the members. Lee, you sent me some good comments. Jeff Trunzo called me and had some comments on it as well, but was prepared, to move forward with the bylaws as they were drafted. We did talk about a couple provisions. So I can run through the more important ones. I can go through all of them if that's your desire. Section 1, I revised to make it clear that even though we're amending the bylaws, that the current members at the time of the adoption of the amended and restated bylaws continue on as members until their term expires, and cleaned up a little bit how the members are appointed, just to make it clearer. One question remains unanswered here that I did not address, and that is, when do our terms begin and when do they end? I've talked with Glenn about this, and I know Ann is the arbiter of all things, and so I don't know how or if we should address that. I'm told that historically, the way it has worked is that the nominees for appointment or reappointment, once confirmed by the Board of Commissioners, at that point are the members of the Planning Commission, and whoever is not reappointed or whoever has, is going off the commission or whatever and is being replaced, they are no longer at that point in time a member of the Planning Commission. There's been a suggestion that terms are for 1 year. It doesn't specifically state that, and so the question is, if you become a member of the Planning Commission when the Board of Commissioners approves you, do you serve only for 1 year from that date, or do you serve until you're elected and qualified? Now, the appointments are for 3 years. So, yeah, so it's a question of when does this 3 years start and when does it end? Given the vagaries of timing of appointments, I don't think we could be in a position where your term would expire before even appointments are made. Conceivably, that could happen. It could be 3 years out from the time that members were appointed to the Planning Commission and still no appointees, from the mayor.
Well, historically, just to add to what you said, historically, you serve, if you were not reappointed or renominated, you served until the new appointments were made, okay, historically.
Well,
So
I
the
guess-
real, but time-wise, there's sort of a question because the appointment is, quote, for 3 years, but there's been occasions when the mayor has not appointed people until November. So do they run 3 years, November to November, or does it end in October or September when the mayor may make new appointments? That's sort of one of the confusing points.
I guess it's a question for Glenn, I
Yeah.
guess, in terms of can it be, until a successor is appointed and qualified? I mean,
We've done it that way. I mean, the problem, the reality is that because you want your terms to be staggered, if you allow the date to deviate depending on when the appointments are made, then you can get out of whack with your staggering. So it almost, in a perfect world, there'd be perfectly set terms and the appointments would be made in time so that you'd never have a question of whether the person serves what's remaining in the 3 years or whether they serve 3 years from the date appointed. But we don't have that perfect world. If you wanted to avoid the staggering getting out of line, then I think you'd almost have to say, here are the terms, and somebody might miss out on a month or 2 months of their term because the mayor and the commissioners don't appoint when they're supposed to, and there's no perfect answer, I don't think, but if you want to avoid if you want to keep the staggering perfectly aligned, I don't know of any other way to do it.
Well, but that raises a significant issue because if, for example, and let's assume that some members' terms, the 3 years is up, say, on October 1st. If they're no longer members of the Planning Commission, potentially we have lost 3 members. We're down to 6, and that can present some serious quorum problems because, as you and I talked, Glenn, you feel that because the code specifies that we are a 9-person commission, that determining the quorum has nothing to do with whether or not somebody is no longer serving on the commission. It's a majority of 9.
Right. So I think the only way you could deal with that is if you made clear as well that if appointments have not been made yet, then sitting commissioners hold over until the new appointments are made.
I would say it probably wouldn't extend their term. It would simply be that they're holding over.
Right.
Would that make sense?
That probably makes sense. I mean, that's what historically we've done.
Right.
So that the definition of, that it is a 3-year term,
You just might
unless you
not-
put in wordage that it has to be, that if the code was changed such that the mayor must make appointments within so much time after the elections or taking office. Again, this has not been something that we have caused. It's something that we've inherited.
Right.
Yeah, I just, from my perspective, looking at it legally, I would want to be sure that no one could question any decisions of the Planning Commission that are made, if that type of situation arose. I mean, is someone going to go to court and argue that certain members of the commission were no longer commissioners because they had already served their 3 years?
Right.
So I think we ought to make a decision and try to avoid, something like that occurring.
Yeah, I mean, the practicality, though, is, as the chairman just said, it's sort of out of your control. I mean, you get handed the appointments when the commissioners, the city commissioners, make those appointments.
Yeah.
So other than, the city commissioners agreeing to put something in the code such as if the appointment is not made, the commissioner who's in the seat, their term is automatically renewed or something like that, which would cause them, or at least give them some impetus to make the appointment at the appropriate time. I don't know how you avoid it.
Yeah, I think maybe you and Rick or you need to work on some verbiage that explains that end game.
Yeah.
Because I mean, you could get into the situation where the mayor does not make appointments, okay?
Right.
On a timely basis, okay, or an expected timely basis. Or you could or the situation that occurred a couple of years ago relative to the commissioners is he made an appointment and the commissioners didn't approve it.
Right.
So he was left at a meeting without an appointment. And which would then add another month or so. So we need some verbiage that deals with a continuance of serving if a timely reappointments are not made.
Right.
Or
And
can
that
it
may
just
be
be
a
your
code modification.
term is the later of 3 years or when your successor is appointed?
Yeah.
Right. Yeah.
That's probably an
But
easy.
does the city, I think the city code addresses the terms, right? So it'd have to be a modification perhaps to the city code. It's not a bylaw specific thing. So I think that it's probably going to have to be a recommendation from this body to the city commissioners that they amend the code to make clear that it's 3 years until your replacement is appointed.
It's conceivable that for whatever reason, the mayor would not, like, let's assume that somebody, there was like a thought that a particular planning commissioner would not be renominated. And if the mayor wanted to keep that person on, he just doesn't just lets it go, and then, you know, you're saving, you know, I guess it's like, do you need to make it so they would be forced to nominate or not renominate, I guess. I mean, that's what I'm
Yeah,
saying.
I don't think you could just ignore,
Yeah.
if a term ends, I don't think you can just ignore the fact that the term ends. I think the mayor must make an appointment or some or reappointment if a term ends.
Yeah, the city code does not address holdovers, even though that's the way we've treated it. The city code does not address it.
Yeah. Okay, this is a discussion time. We're not going to settle anything today.
Right.
But that needs to be addressed because and it needs to be addressed, not so much, well, for the point that Rick mentions, you don't want to then make any decisions that might be challenged, okay, because you didn't have a properly sitting board.
Right.
That's one thing. And then, because we're going to have to deal with elections of officers, which we're required to do by state code, you don't want to start electing people that
Right.
haven't been appointed or, you know, it's complicated. So we need some clarification there. Because it has happened.
Right.
I think in the last 5 years, it's probably happened at least twice where there's been delayed appointments for whatever reason.
I guess we can chat after. The new section 2 is actually an old section. I just moved it up had been put in further down in the bylaws. It just made sense to put it up front. And then the rest are renumbered sections. Section 3, I put in some clarifying language. It seems to me as though, you know, for example, when the new city hall was being constructed, all the commissions and everybody was meeting at the fire hall. And it seemed to specify that we had to meet in this room, which, you know, I think no one, you know, we may have a situation, for example, where we might want to, you know, for a charrette or something, meet over at the school, you know, because of a big auditorium or something. So this just gives us the flexibility to, you know, as long as it's within the city of Rehoboth Beach, we can meet. And it also clarifies the ability to cancel planning commission meetings if there's nothing before us for consideration or for other good reason. You know, planning commission meetings are from time to time canceled all the time, but it didn't say anywhere in here what criteria you would utilize. Oops, sorry. Section 5 is really one of the biggest changes to the bylaws, and this deals with the annual election of officers. In order to, I kept the concept of electing annual officers as soon as practicable after the appointment of the members to the Planning Commission, and indicated that under no circumstances can that occur later than December 31st in any year, because we have to comply with the state statute as well as the city code. We have to have an annual election. As the chairman said earlier, December 31st seems to be the reasonable date. It also,
By the way, the state code only calls for the election of a chair and a secretary, not a vice chair, so we've added the vice chair. But I don't see any problem with that.
Nope.
the language makes clear that any member of the Planning Commission is eligible to be an officer. And that there be a notice given by either the current chair or in his or her absence, notice by the vice chair to the other members at least 15 days in advance of the date of the Planning Commission meeting at which the election of officers will occur. The reason for that 15-day notification is because we included somewhat of a modification of the form that the chair handed out at the last meeting that had been used previously at some point in time by the Planning Commission that gave the members an opportunity to either nominate themselves, suggest someone else for a position, or at least express a willingness to serve in one or more positions if nobody else, was willing to serve. And so I took that as sort of a template for Appendix A. So the reason for the 15-day notice is to give the members of the Planning Commission an opportunity to fill out that Appendix A, submit it to the secretary, which would be Ann, who would then provide prompt notification to the members of the Planning Commission as to who either nominated themselves, nominated others, or expressed a willingness to serve in certain positions if need be. That gives everyone an opportunity to, consider, the people who are interested in serving, or to, consider the people that have been nominated by others to serve in positions. One question that has arisen, and Glenn and I have talked about this recently, is the issue of a secret ballot in the event that there is a contested position. In other words, more than one person seeking to be elected to one of the officer positions. Glenn, I'll let you take it from here on that
Sure.
question.
So my view on that question is, because we have the Freedom of Information Act, which says that all meetings shall be open, my view is that secret ballot is not appropriate. There's an Ohio case that I shared with the vice chairman. I don't have a specific Delaware case, but they have language in the Ohio Freedom of Information Act that's similar to our language in Delaware. And the court there at least said, your meetings are supposed to be open, and it's not enough just to open the doors, but then conduct business by secret ballot, because, generally when people are elected or appointed, people are supposed to know how they're voting on and what they're voting on. And if there's a reason that a particular group of citizens don't like the way an individual selected the secretary or the vice chair, then they can go and, the political process plays out. So that's the thinking on secret ballots. Because you're a public body, your votes are supposed to be publicly made. And unless there's a specific exception in the Freedom of Information Act for an executive session. But as we know, even there, decisions can't be made secretly, so.
The whole idea of a secret ballot, I had raised that issue because of the awkward nature of what happened. Let me just say something. Historically, getting people to volunteer for the 3 positions of officers has been a problem.
Right.
So it wasn't a question that we had a gigantic base of votes and multiple applications. Usually you had to do some arm twisting to get people to take a position. We did have an awkward situation where last year we had 2 people vying for the same, or asking to be in the same position. And that created sort of an awkward situation voting-wise. And rather than have to deal with an awkward situation, that's why the question of secret ballot. The results of the ballot are still known.
Sure.
They're still certified. We have a secret ballot every time we vote in this country, okay, for any position, elected position. So it seems to me that as long as you could certify that the votes are proper, that the idea that the ballot is submitted secretly, it seems inconsistent.
So do you think then that you could, any vote that you were taking, you could take by secret ballot? Would the same reasoning apply? Because it's going to be uncomfortable to tell a developer that their application.
No, I think votes on matters of business have to be open, of course. It's just the question of this officers and competing. If people wanted, the only rationale that I had for a secret ballot was to avoid the embarrassment of the conflict of somebody not voting for somebody versus voting for
It's going
somebody
to
else.
chill your deliberations, as it did last year, when it's going to chill your deliberations when the two people being considered are sitting right there with you. I understand all that. I was asked a question, and my opinion and view is that open meetings mean all of your votes have to be open, and you cast them how you cast them.
Let it be open.
I agree with David. And I read the case. I don't think it is based on sound reasoning myself, because I do think that not allowing, in this particular circumstance, not allowing a secret ballot has, as you said, a chilling effect on the process. And one where, albeit a 9-member planning commission, we're still a small group, and we are all in a small city. And I think it puts both anyone seeking a position in a situation where more than one person is seeking that position. I think it puts both parties, both the person seeking the position and the members voting on that position, in a very awkward situation. And I think it also negatively impacts potentially, the collegiality and camaraderie that we need in moving forward in a collaborative fashion. So, yeah, as I said, I think the Ohio court, was it Ohio or Iowa?
Maybe it was Iowa.
I
thought it was
thought it was
Ohio.
Ohio.
Yeah.
I felt that their reasoning was illogical. For those reasons, I'd be interested in knowing what, if any, legislative history there is in Delaware to the FOIA.
Well, we have time. Why don't I take a look at it? Because I mean, I did some quick research and did a gut check, and that was
Yeah,
my
I know I
response to
sprung
you,
it
so-
on you.
Right. No, that's fine. I'm happy to look at it, but my anticipation is that it'll probably turn out similar to what Ohio did. There may be something in Delaware that says absolutely the opposite. In the
about
context of
looking at it?
voting on officers, maybe there may be a carve out for voting on officers.
Take a look at it. The intent, this is a small body. In the years that I have served on this body, I have to say that there has been, I know of no time when there has been real acrimony between the members working on this board. They may have differences of opinion on different subjects that are presented to us, but as a group, they work together. And I think anything that might impede that working relationship should try to be avoided. I would say, look at the mayor and commissioners. How is the vice mayor appointed? That's not even an election, is it?
No, that's strictly, I believe that's strictly the mayor appoints, and
Yeah.
it's done. Yeah.
So is that any different than having an election? And especially, I mean, the argument I would have is if the FOIA is the concern, okay, if the FOIA is the concern, I would just counter that with every election that we have for office in this country is by secret ballot. That's the one unique thing in our democracy that we do have.
Yeah, but I see the distinction between the two of those, though. I mean, the reason that's secret ballot is that so nobody can coerce you to vote a certain way. I mean, I don't know if it's still the case, but it used to be the case that if taking a photo of your ballot while you're in the booth and sharing it publicly was a crime, misdemeanor, something. I don't know if it still is or not, because the concern was that employers would say, if you want to keep your employment here, take a picture of your ballot, bring it to me. If you voted the way I told you to, you can keep your job. So there's a lot of good reasons for those to be done by secret ballot that I don't think really translate completely to an elected or appointed body making decisions in an open public setting. But
Let's take a
I will
look
do the
at
honest
it.
research. And
I mean, our intent is not to hide who's elected. The intent is really to discourage any acrimony that might occur by virtue
Yeah, I
of.
mean, unfortunately, in the Ohio case, I mean, the city had the ability to demonstrate who had been elected, and they had sticky tabs or whatever, and it was in the city records, and the court said, nah, still doesn't work. So. Okay, any questions or comments on this section?
Yeah, break it up into more sentences and burger dots and paragraphs. Come on, you've lawyered us.
One of my business partners always accused me of writing run-on sentences, but I realized he didn't know what a run-on sentence was. Okay, section 6 is really just the language there is just clarifying language, as is section 7. However, question has been raised as to the role of each of our secretaries. We have a secretary that we elect, and we have Ann. And what are original documents and what are documents? It's a question of who signs, official documents, rather. The current bylaws say that Bunky, as the current secretary, is the person who signs official documents. The recording secretary has responsibilities also, and so what are official documents versus documents?
Okay. I'd like to make a comment.
She can, yeah,
My question when I brought this up was between the chairperson and the secretary, not
right.
me
Oh,
as the
yes, right.
recording secretary. Because in your bylaws, it says, under the third one, under chairperson.
Right, yep.
Sign documents of the planning commission. And then also under secretary, it says sign official documents of the planning commission.
Right.
So I'm wondering as to who I'm supposed to take the documents to.
Mr. Solicitor?
So the question is, who amongst, what does the bylaw say again?
Under the chairperson, it
Right.
says sign documents of the planning commission. And then under secretary of the planning commission, it says sign official documents of the planning commission.
both have signatory power, right?
I think that's as simple as that. I think they're both able to sign. It doesn't mean that.
Yeah,
It does, right, it doesn't mean that, it's not, it doesn't mean that they've made a mistake and that there's two people named as who signs official documents. I think it generally just, I think it is as simple as saying either the secretary or the chairperson can sign.
Move the word official.
I understand that. Can we clarify it for the bylaws?
Sure.
Yeah, I think we can
In
just
10
take out,
years'
yeah.
time, I may not be here.
Right, right.
I guess we could simply take out the word official under the
well,
secretary.
historically, if there's been a subdivision or minor subdivision, and it's completed, and they notify, the applicant then notifies the city that it's been completed, if it's been certified, I think the chair signed off on that document.
Yeah, I think as the level of the document is elevated, for example, if we were sending something to the State Office of Planning Coordination, I'd expect the chair.
The chair to
would
sign it.
Right.
Yeah.
Whereas other matters, resolutions and things can be signed by the secretary. So I think we can just say that, has power to sign planning commission documents in each of them.
Okay. Section 7, under the recording secretary, again, these are really just clarifying insertions or corrections in terms of what they are. Section 8, I was recommending that be moved to the policies and procedures. When Glenn reviewed this, he was in agreement with that. So that would come out of the bylaws. Section 9, again, was just a clean up the language. Section 10, was, again, just clarifying language. Section 13 is unchanged. Section 14 is revised to say that the commission rules, policies, and procedures can be amended at any meeting by a vote of the majority of the members of the planning commission present and voting. provided 5 days' notice is given to each member. It seemed to me that requiring a vote of the majority of the entire members could be problematic depending upon, whether or not members are not able to attend meetings. Amending the bylaws, amending the rules, policies, and procedures, could be held up, simply by people not showing up for meetings. I know that David disagrees with me.
Vehemently, or somewhat less. My argument,
What section? I'm sorry. What's the-
14,
It's section
his item
14.
14. It originally read.
It also plays.
Yeah, it originally read the entire membership, that is, the entire members of or membership of the Planning Commission. That's the way it originally read in the existing. My argument, the way Rick has drafted it, is that if you, by chance, have a minimum quorum of only 5 people, and if you have a 3-2 vote, you now have 3 people out of 9 people potentially changing the bylaws. And I just don't think that's right. I understand that there could be, well, Rick actually raised the question, what if somebody objects to the changes and he boycotts the meeting? The likelihood of that happening is pretty remote. The person objecting to changing the bylaws could always vote against them. And quite honestly, if they went to the point of boycotting a meeting and did it for 3 meetings in a row, you could remove them from the Planning Commission
But
for
I don't
not.
think this means that you couldn't take a vote if they boycotted the meeting. I think this just, as originally written, I think it just means you need 5 votes, whether people are there or not. You need 5 votes to amend the bylaws. A majority of the,
Do you think that's what it means?
I don't,
That isn't what it says, though.
I don't
so
think so.
commission rules, policies, and procedures may be amended at any meeting by a vote of the majority of the entire membership. So, I've seen these provisions before. This is an interesting provision because when you require a majority of the entire membership,
Okay.
for example, an abstention is counted as a no vote, whereas if you have just a simple majority requirement, an abstention doesn't count as a yes or a no. So these supermajority type provisions have meanings beyond just what
All
they're.
right, so your interpretation is it's a supermajority of 5.
Yeah.
Of 5 votes.
Right.
So what I assumed that if you had a 3-2 vote, that would not be sufficient. You would need 5 positive.
No, I'm sorry, the amended, the way that it's proposed to be amended, 3-2 would carry the day.
And I think that's
Under the-
wrong.
Under the original, as it is currently written in your bylaws that are in existence now, I think that if you only had 5 members present and you were trying to change the bylaws, you'd need all 5 of those members to vote the same.
My preference would be to leave it that way. I think it's dangerous if you have a situation where 3 people out of 9, that is a majority of the present quorum.
We had a situation recently in Lewis, you might have read about it, where it's a 9-member planning commission, 2 people voted, it got down to 2 people voting on preliminary consent for a major subdivision. So,
That's not good.
so we're going through the bylaw exercise in the Lewis Planning Commission right now as well. But the good news is I don't get to vote and you guys have to make the decision.
I was trying to, this plays in also to section 24, which is how you go about amending the bylaws. And the way the bylaws stand now is that a majority of the quorum can amend the bylaws, which is not something that you would agree to at this point.
Yeah, no,
But that's what's in our current bylaws. And I was trying to make the standard for amending the bylaws and the standard for amending the rules, policies, and procedures the same. And
I'd like to see it as my own personal preference, and I think from an open government standpoint, I think you'd be safer if you had a supermajority of, that is a required of 5 total votes. And if you can't get a quorum in a particular meeting, I don't think the bylaws are that critical that you can't delay a meeting or something like that. But it just seems to me that you're sending the wrong message if you allow something as like bylaws or procedures, to be changed by a minority vote. It just doesn't seem logical to me. Anybody else?
What is the process for amending them? Anybody can propose an amendment? And
Yeah.
Yeah. And you have to give 2 weeks' notice to
Yeah,
the
you have to.
members. I mean, there's a
So
time
in
period.
theory, if that happened with 3 and there was a majority that didn't like it, they could ask for a revote in the next meeting. They could amend it back. In theory.
Technically, I believe that's true. Yes, yeah.
Rick, in terms of crafting this, do you find it objectionable to go with the idea of a supermajority, which then, if there is only 5 people at a meeting and the other 5 were absent, that if those 5 were in agreement, that would be enough to carry the day, as opposed to the simple majority, which could be the 3-2 example that David brought up? Is there let me rephrase that. Does it achieve your objective and the purposes in a positive perspective if we look at it from a supermajority perspective? So if there is just 5 people and 5 absences, 4 absences, you still could have the bylaws amendment passed.
Theoretically, you could have the bylaws passed by 5 affirmative votes to amend, yes.
Okay.
But, you know, I still think that presents potentially problems, you know. I mean, let's think about the situation that we're currently in. We're missing 1 voting member, namely Susan. And so if you have to count that empty seat in terms of determining a quorum and what would constitute a majority vote, it doesn't seem to me that it should depend upon whether or not a seat has been filled or not.
Right, but if we have 6 of us here right now,
Yeah.
so with even if it was just 5 of us, that would be sufficient if all 5 voted in favor of whatever the amendment was.
But you're saying in that case, it would have to be unanimous.
I'm sorry, say what?
You're saying in that case, it would have to be unanimous 5.
That's correct.
Even if the other 4 aren't voting.
Right. I think well, actually, this is an example, maybe there is contention here, but I think the majority of the issues related to that are not going to be something that is so dramatic that it's going to lead to consternation among, you know, a real difficult situation. I think it's going to be fairly straightforward in trying to envision this type of thing. I think we'll run into more issues that are difficult when we deal with the issues that come up for major subdivisions or minor subdivisions and those kind of things. I think from the bylaw perspective, it would probably be fairly easy to get substantive agreement on the topics as we discuss them and go over it. So I'd be comfortable with, I'd be comfortable, I think, with 6 of us here and getting 5 of us to vote in favor of something. So I would tend to support the supermajority approach because I think it addresses, from where I'm sitting, most of the issues that you're concerned about. Not all, but most.
All right, any other comments on that section?
To be thought about.
To be thought about, yeah. Let's see. That brings us to the section 15 agenda. Again, that is something that I recommended be moved to the policies and procedures. And Glenn agreed that that was probably appropriate. Same with respect to section 16. That seemed to me to be something that really wasn't a bylaw provision, but again, should be moved to policies and procedures. And section 16, major subdivision applications. I had originally thought that this should be moved to the policies and procedures, but I think you felt it should stay. in the bylaws. So there's that to consider. 19, again, was a clarification. Section 20 is to try and deal with the time issue because the bylaws stated 3 p.m. here, and I think it should, you should just have to notify the secretary before the time of the meeting that you're not going to be present. 21 was a clarification. 22 is also just clarifying and referring back to the procedures in Section 5. 23 is unchanged. The old 23, as I said, was moved up to Section 2. And Section 24, which is the amendment of bylaws provision, which we were just talking about. Well, we've covered that. I want to back up to Section 9. Lee raised a question as to whether or not there would be enough time for that process in terms of referrals from the Board of Commissioners. It does, I mean, in my view, it does say, if possible, be placed on the calendar for consideration and action in the first meeting. But, there is a question, I mean, should we identify how much time we're actually going to take and not leave it open-ended? There may be situations where the next meeting of the Planning Commission could be the following day from a Board of Commissioner meeting. Obviously, that's not enough time for us to consider something that can't even be put on the agenda.
From my perspective, and we've always tried to comply with requests from the commissioners to handle something. I mean, we've had a couple this year where we effectively dealt with them as soon as possible. There's been some situations, for instance, if you go back when there was a request to do the lake study, okay, or the tree study. There we had to do a bunch of homework. We really had to, we understood what was involved. I mean, we could essentially say we're going to do this, but to actually take it up to start the process was not necessarily convenient, maybe because of other business that was before us. So we may have essentially discussed it and said, we've had this request, but we will deal with this at the next meeting. I mean, it just depends on what it is they've asked for.
I guess if I had to guess where this requirement came from, it probably came at the request of somebody on the Board of Commissioners. And was not something.
I don't know
that
what the
was,
history is.
I just think maybe we should clarify things, to accommodate the kind of examples that you just referred to, that there maybe it's a facts and circumstances kind of thing, and rather than just if possible, which is.
I mean,
Could be if practical. I mean,
Yeah.
if practical. Yeah.
I mean, if I had to add something, I think I would ask that any such requests that come from the mayor and commissioners come as an official proposal as opposed to a voice request carried by the solicitor or anyone else, as has been the case in the last, this year. And I think that's wrong. I really think that if it's important enough for the commissioners to refer something to the Planning Commission, there ought to be an official proposal or motion on the part of the commissioners and mayor, and laying out the specifics of what they're asking for, so that there is no question about what it is we're supposed to do. And I've mentioned this to Glenn before. And I know some of the commissioners have said, actually at those meetings, that they had preferred to actually make a proposal and do it, but it wasn't done. So it just seems to me that that's a proper way of doing it. I mean, I look back at the tree ordinance, the lake study, it came with a defined boundary of what we were to do. So, again, that's not from our side, it's more from the commissioner's side, but,
Well, and I think the most recent situation where there was a referral from the Board of Commissioners, it was, Glenn, correct me if I'm wrong, but I believe that they adopted a motion or resolution or something to refer the question of whether or not to rezone. Is that correct?
Yeah, there was, I think I crafted something handwritten during it, but it was not a formalized document that laid out very clearly what the criteria was or should be.
well, the rezoning issue, we actually did take up,
Yeah, we did.
okay? The one that we did not take up was the resolution related to clear space,
Right.
okay? And my reaction when that was presented to us, it came too late to disseminate, to study, that is relative to dispersing it to the members of the commission. And I just didn't think that it was done in quite honestly, in a proper way. So the preference would be to have those things codified and handed down so so it becomes very clear what the charge is, and then we can deal with the timing.
Well, we can certainly, I think, look at that and see if we should make some changes in the language. That's all I had on the bylaws. Obviously, we need to take a look at the policies and procedures. I didn't attempt to amend those until we had an opportunity to discuss the proposed changes in the bylaws. And I don't know if I've missed anything that we should be including in our bylaws that, either wasn't there before or that I have, not included now. Should also take a look at the policies and procedures, as I said, and see if there's anything in the existing policies and procedures that is either not what we follow as, a procedure. And if that's the case, then I think it ought to be changed as well.
I think one note I had, Rick, on the nominations, is it clear whether you can self-nominate?
Yes.
Yeah.
Yeah, if you look at the form, which, is the form in here, Andy?
Yeah,
Ann?
Appendix A.
Appendix A? Yeah, the third part of the form, or the second part of the form.
The first part of the
The first part,
form,
I'm sorry.
yeah,
It is
no,
the
go ahead,
first
Dick.
part. Yeah, you can self-nominate. I mean, historically, the problem has been getting people to volunteer, okay? Quite honestly. And
The only way they're nominated is when
yeah,
somebody else
and
nominates
I'll
them.
be very honest, in the past, and I know Rick was unhappy with this, but in the past, and I didn't start this, it actually started, I think, well, my experience was with Pal, but basically, he would choose a chairperson of a nominating committee who he knew did not want a position, okay, for whatever reason, okay? And then that person would essentially do this. Now, whether they did it properly or not, that's another question. This, I think, is a little more formal. There's probably a better way of doing it. But that was the intent of you picked someone that you knew didn't want the position or a position and said, please serve as, and contact people.
They would survey them.
Yeah, and what that person would do is either by email or by phone conversation, talk with everybody, say, would you serve? Do you want to serve? What would you, do exactly what it says on the form. Okay, now whether they did it properly, and then they would come with a slate. And historically, we had to do some arm twisting very often to fill a position.
And that could still happen.
Yeah,
So,
I was curious, I can't find the language, but there was something that indicated that if nobody was interested in a position, that there'd be an election, and somebody would be elected, but what happens if somebody who doesn't want the position gets elected to the position?
Well, they can decline. And that's actually happened. That's actually happened. So if you talk about the actual work, maybe just since I've done it and you haven't, okay? There's a fair amount of work for the chair. Chair, the agenda is the biggest thing, okay? Communication, there is a fair amount of work for the chair. The secretary, by and large, for the things that we've seen in the last year or so, really does not have all that much to do. But there is one situation, which we haven't had in a while, where the secretary does a lot of things. And that's a major subdivision. And in fact, the reason why in the site plan review that the secretary is not involved in the same process, because the site plan review is essentially almost the same as the subdivision, major subdivision, is I think that what happened was we had a number of major subdivisions, and the existing secretaries found out how much work there was. For a major subdivision, the secretary of the planning commission works along with the chief building inspector or building and licensing in communicating with the applicant. And in fact, does an awful lot of the communicating back and forth with the applicant prior to the applicant ever coming before the planning commission. So rather than just the building inspector saying yay or nay, it's ready to go to the planning commission, the secretary has that power during a major subdivision. And there's an enormous amount of work. And I think what happened, Glenn was part of the process of drafting the site plan review. I think some of the people on that committee probably took a look at the work that was going on by the secretary during subdivision and said, maybe the secretary shouldn't be involved in the same way during the site plan review. That's something we might want to revisit, okay? Because it provided a level of communication to the planning commission of what the status and the process was. But there is, under a major subdivision, there's an enormous amount of work for the secretary. It is what it is. Huh?
I said, make sure you avoid that position.
Yeah, well, and that's part of the problem.
Yeah.
That's part of the problem. Okay, so. Rick, thank you.
Okay.
Ann,
I
you,
have a comment
oh, yeah, okay,
on number 3.
okay.
You're saying, or at such other location within the city or Rome. There may be a problem with that because of recording of the meetings, and now that we're doing live stream,
Yeah.
it's only going to be done in this room.
Yeah. But there may be situations that cause us not to be in this room. Could be.
Are we required to have every meeting of the planning commission live streamed?
No, I mean, the city commissioners have set a policy that they want to when they can, but I don't think there's certainly the state law does not require that you live stream or that you audio record even. But the commissioners have set a policy that their preference is for live streaming, but I could certainly see if there was something threatening this building and you still wanted to meet in the library, you'd meet in the library.
Yeah. I mean, it's happened before. But,
Right.
yeah, so. Thank you. Thank you, sir.
Just one quick point to
Yep.
follow up on a comment that was made. The revised section 5 does indicate that, if in the event that no member of the planning commission indicates an interest for any such officer position, the members of the planning commission shall elect a member at the aforesaid meeting to serve in such officer position. So, yeah.
So,
I don't think it's indentured servitude or anything, but it's close to it.
okay, to be discussed further, I guess. Okay. Moving on. Mr. Molina. Yes.
Good afternoon, Mr. Chairman and members of the Planning Commission. My report I submitted previously, I believe you had circulated regarding our permit issue analysis for the month of September. And I hope you all have received it and have a opportunity to review it, and if you have any comments with that. Now, the report only indicates what's going out. It doesn't show what's coming in. Okay, so a lot of applications for new constructions are still in limbo until they have been issued. What I want to do in the future is have the IT individuals come in and offer a presentation to the Planning Commission, which they are willing to do, on how you can access all that particular information. So I think it'll be open, it may be available to the general public as well. So if you could take that under consideration as you move forward. I just want to add, there has been no application on updates on any of the hotels.
Okay.
Okay. However, we did receive a complaint today that there are soil borings underway by a licensed company, which we sent out and confirmed at 415 Rehoboth Avenue. We're at Clear Space.
Oh, clear space.
Clear Space was using. And Agave has been almost completed with their review. We are still waiting for additional documents, so we may have a new restaurant in town.
Don, why was there a complaint? There was no permit for that, or what?
No,
Why
just a
was-
soil borings exploratory.
No, but you said there was a complaint?
We received a complaint that they were doing work there. They came in,
We're doing work there.
yeah, basically soil borings.
But your question is why is somebody
is there a
complaining
complaint?
about that? Why
Yeah.
can't you do a boring on your own
It's just
property?
somebody called.
Oh,
They want to know if they were licensed.
License to be there.
okay.
You can't get away with anything in this town.
A question. Is there any discussion, at the level of building and licensing or the city on this issue of during demos? I noticed that there's a house being demoed at the end of Newcastle on Scarborough, and it's being taken apart piece by piece because it's essentially recycle. I don't know what the company is, but we had talked at one time about encouraging that kind of demoing, either with Habitat or people, obviously there are other companies that do it. The argument against it was that it delays the demoing. It goes slower, and you may not be able to get those companies to come in at the appropriate time. But it just seems to me, even though that process, I was watching them do it, and it sort of taking this house apart brick by brick, and takes a while. But the idea of being able to recycle that material is encouraging. Is there anything going on?
We have discussed that, and when we meet with the contractors, and a lot of them are aware that we do encourage them to dismantle the house for another purpose if they have an opportunity. Usually when they start doing, they want to get the work done because they have other jobs pending as well, and they want to continue that. What is going right now with the assistance of the city solicitor is that we're beginning to, we have an ordinance on the way regarding requiring silk fencing and other protections to keep silt from running onto the right of way.
Okay, well, we've always had that.
Well, we didn't have it for we didn't have it under, we couldn't control it under 5,000 square feet. And I believe now it's to anything 2,500.
2,500 square feet. Okay.
David, in other jurisdictions I've worked in, there has been actual official requirements that usually they're tagged to a site plan approval or a rezoning or something like that, where you use, maybe it was reasonable efforts to give Habitat for Humanity, for example, access to take whatever items out of the house that's being demolished that they can reuse. And sometimes they take the windows, the toilets, the sinks, the plumbing fixtures, the doors. But it is a requirement or a condition of an approval that was officially done, and we would, usually it worked out okay, you know, you would have plenty of time, and you would just call the local Habitat for Humanity, tell them what you were doing, and arrange for a time for them to come and take whatever they want to take that they can use, and,
It seems to me we ought to be encouraging stuff
Yeah.
like that. And the question is, do we need any code change related to encouraging that?
We could discuss it.
I mean, we talk about this kind of stuff frequently, that in a more incentive-based code. I mean, I think that's a perfect example of something you could create a code provision that says if you do this, when you dismantle, then when you put back up, we'll allow something more than what you otherwise be allowed.
Well, I mean, the question is, do you grant incentives? I mean, there's always that question is, do you create some form of incentives to do that? I mean, that's one way of encouraging it.
Right.
Okay, thank you. Anything else?
No, that's it.
No?
Could I ask Dom just one quick question? What do you foresee as the timing for a presentation by the IT folks that you were
It's up,
talking about?
it's up to you. They were, the only condition that they would like to be honor is to be able to first in and first out. So the earliest you could get them on the agenda, the better, and because they have their time limitation as well. So if you want to do it next month or 1st of January, we could do that as well.
Okay, thanks.
Glenn? Got anything for us?
The only thing I don't know if everybody's been following it, is that the commissioners are engaging in a discussion right now about administrative variances and whether they're going to implement a provision that would allow for an administrative variance. So the state code allows a municipality to set up a code provision that would allow a building inspector to deviate from the zoning code up to 1 foot. So there's a draft ordinance that's there that they are considering now that would allow that administrative deviation of up to 1 foot for setbacks and one other area, I forget what. Or is it just setback? I think it's just
It's
setbacks.
primarily
It's just
setbacks,
setbacks.
but existing construction, I don't know if they're considering new construction.
They are considering new construction. It's on the table, yeah.
Not boundaries, though.
Setbacks, so you could encroach up to a
Setbacks are
foot.
different than boundaries.
Property boundaries?
Yeah, property boundaries.
No, I mean, nobody can deviate property boundaries other than green dollars. So,
Well, no, I was thinking of the one on Rodney Street a couple of years ago.
and you all can deviate.
Well,
Yeah.
where Midge Reed, where there was an error
Right.
in the original layout of, because they used chains and
Lot wasn't
whatever.
as long as
Right.
they thought it was.
And there was a 100-foot lot that they wanted to subdivide, but it was only 98 feet or 99 feet.
Yeah, this would purely be for zoning deviations, not for property boundaries that
Okay, all right.
the purview of you all.
Okay.
Is that going to go through a period of public comment?
It will. It's, in fact, I think at their meeting this month, they're gonna set a date for a public hearing on it.
Okay.
Yeah.
As a planner, although it has nothing to do with faith in Dom, but I think because of the nature of our setbacks and the limited scale of them in residential areas, I think you run the risk of ending up with a slew of every administrative request to exceed the setback by a foot automatically, which by then circumvents the code to begin with.
Right.
So I think there'll be a lot of public comment. I know there will be from me.
I think there will be, and there should be. The current draft of the ordinance includes a provision that says the building inspector is supposed to apply the legal standard, the exceptional practical difficulty legal standard that a board of adjustment is supposed to. So it shouldn't be a rubber stamp coming out of the building and licensing office if those standards are applied, which aren't always so easy to apply, but the intent is for it not to be rubber stamped, because as you say, in our relatively small lot sizes, if you only need 6 feet of a setback on a side yard and 6 feet on your neighbor, pretty soon you could get to 5 and 5, and all of a sudden you're only 10 feet apart. And
Because, I mean, as we've seen so far is that with the setbacks as they're being employed, and it's been going on for a number of years, is they do it within the inch. I mean, they literally, I know Dom has the problem now, but it was under the previous inspectors as well. They had to take a TEP measure out there, you had to take the line, you had to strike the line, they were built that closely. I think I'm one of the few people that went in the opposite direction, and my side setbacks are twice what they need to be.
All right.
So I'm the oddball.
If you went the route of administrative variances, would that then create automatically non-conforming lots?
No, I think I mean, if an administrative variance is granted, obviously it would create a legally non-conforming lot.
It would create a legally non-conforming lot.
Right. I mean, I think there's, and again, I don't have a vote, so from a policy perspective, I don't, my views don't count, but what raised the issue, I mean, I guess some of the ones that I've heard that certainly do make sense is, I can remember a Board of Adjustment application where this applicant needed to put siding over the siding that existed. They were built to the line and to the setback line, so they needed like a 3/4 inch or a 1/2 inch variance for the siding that was gonna go over it. That probably makes sense for an administrative variance, but all the way out to a foot, it gets a lot more dicey, I think.
Thank you.
Not to mention the $1,000 to go to the Board of Adjustment.
Right,
Yeah.
right.
Anything else?
That's it. Thanks.
Ms. Ann, got anything for us? No applications. Okay. I guess everybody probably realizes that myself, Monkey, and Paul will not be reappointed. And so you will have a newly constituted planning commission soon. Although if you look at the paper, there may be a bit of consternation over the mayor's
The
appointments.
newspaper next door downtown.
Yes,
Yeah.
Mr. Flood? It's your reporting, it's your writing.
It was that front page article. It wasn't fake news anyways. If I could, I'd just like to personally take this opportunity to thank David, Bunky, and Paul for their many years of service to this city. And, admittedly, we are going to be losing, the benefit on this side of the dais of your knowledge and experience. My hope in going forward is that we all know that you care about this city, and I think whether you're sitting on this side or the other side, that carries through. And I personally, look forward to, getting your input and guidance and counsel as we move forward. And so, again, I appreciate, all that you've done for the city. I do want to say, however, that, and Steve Kaufman, who's one of the nominees, happens to be here today, and I think he'd like to introduce himself. Before he does that, I would like to say that I hope people don't jump to conclusions and prejudge the ongoing ability of the Planning Commission to carry forward in a responsible fashion. I don't believe that we are starting all over again on any of the matters. The site plan, the sketch reviews that have come before us changed dramatically from meeting to meeting. And as far as the CDP is concerned, we have made progress, and I think that the fact that we took the step to implement a survey, which hopefully is going to provide us with some very interesting information and will serve as a launch pad for the newly reconfigured Planning Commission, is an opportunity for us. And I have met individually or spoken, at least on the phone, with each of the nominees that the mayor is putting forward. I personally believe that they are extremely well qualified, that they will lend a great deal of experience to our deliberations and consideration. And I have no doubt that we will be able to produce an extraordinary CDP at the end of the day. And I would just hope that no one undermines the confidence of the public in what will be produced by this body going forward. I think that's very important. With that, would it be appropriate for Mr. Kaufman to introduce himself?
Yep.
I think that's good.
Good afternoon. Thank you for the opportunity. to
Name
ser-
and address.
I'm sorry?
Name and address.
Okay. My name is Steve Kaufman, and my address here in Rehoboth is 200 Stockley Street, or you would say Stokely Street. I did want to say thank you for the opportunity to introduce myself. I wanted to come today to listen to the Planning Commission, to your discussions. I found them interesting and enlightening. I can see there are a number of issues you're considering. Just by way of background, my wife and I have owned a house here.
Speak closer a little bit to the microphone.
By way of background, my wife and I have owned a house here since 1992. I've recently retired from my law practice. My area of expertise was municipal law and land use. I was originally in public service as a county attorney for Montgomery County, and then the last 40 years I've been in private practice. And my areas of expertise deal a lot with, or very much with, what you discussed today and the things that the Planning Commission will deal with. I'm looking forward to helping the city reach its goals and its future plans. I have not met, I don't believe I've met or been introduced to any of the other nominees, so I don't really know them. The only people I do know is I do know the mayor. I have met Rick, and I had a meeting with Susan Gay. I always wanted to avoid getting into my areas of law practice down here over the years, but now that I'm retired and I know the city is thinking about a new comprehensive plan, I thought that it would be a good idea if I did agree to serve, and when I was asked to do that, so I agreed. And I just want to say I have really much enjoyed meeting you all today, and I'm looking forward to my service. Thank you. Okay.
Good luck.
Thank you.
Thank you, Steve.
What brand of aspirin do you like?
I've been in some very long meetings in my time. So.
Any other comments?
I wanted to make one, and thank you, Rick, for making those comments. But I just want to say that I'm very grateful for the opportunity to have served on the Planning Commission for the last 9+ years. I began where I knew very little, and I ended with knowing a little bit more, but not a lot. So I just think it's been just a great experience, and the opportunity to be able to serve in the capacity for either an institution or a cause or whatever that you feel strongly about. And I say that having worked on not-for-profit boards and so forth is a very rewarding experience, and I recommend it, and it's been really great for me. I also want to thank the guidance provided by our fearless leader, and David, and also in the past, Pal Littleton. They were the two chairs that I served under, and it was a tremendous experience of leadership and organizing a group of people and making a very collegial group. And I want to thank this group in particular. There was a comment made that I read recently that alluding to the fact that there was discord on this commission, and I don't think there's anything further from the truth. I'm very impressed with the people on this commission. I think they've all served extremely well, and I leave it, I think, in good hands in that regard. And I wish you all that remain, to continue your service in that way. I also, lastly, want to thank, I think, the person that holds this whole thing together, which is Ann. Ann, you will learn pay respect, okay? It's due. But thank you so much, Ann, for all that you've done. We have done a really crummy job of showing you our appreciation over the years, but you earn your keep in so many ways and serve the city and us in tremendously. So I thank you all. So that's my piece. Thank you.
Ditto. For me, it's 13 years, plus or minus a few months. One of the things that has amazed me over that 13 years, I've served with a whole variety of people, very diverse group, was their ability, A, to work together, as Bunky has indicated, and B, to put aside their personal views about particular land issues that came before us, and basically to deal with whatever issues came before us by the law. And sometimes that's not easy to do, but I think, as far as I can remember, every person that I have ever served with has been able to step up to the table and do that. And of course, the other thing I think is, very fortunate, people that I served with before, Pal Littleton, reinforced the importance of communicating with the public. Our job is not to make decisions based on what we personally think about a particular project or that is before us, but basically to represent the city and represent the people of the city in the best interest as we can. And it's very, very important, I personally think, and sometimes we bend the rules a little bit and to the point of it being painful, but to listen to the public. We have always allowed the public to speak. We have seldom set limits on time. Sometimes we encourage them to speak a little bit less, but basically if somebody has something to say, even though sometimes it's painful, we have a right and an obligation to listen. And I hope that the new Planning Commission will continue in that effort, because it's, I look at some of the commissions and the committees that meet, and there's very often a bit of acrimony in the audience that arises from time to time, and I don't think we've really ever had that. I mean, we've certainly had people in the audience that disagree with us and have particular views, but by and large, my experience is that they've been well-behaved and given the time to let something off their chest and talk about it is probably better than limiting their ability to talk. It's the way democracies work, and I think this commission in particular has benefited from doing that. So I just hope that it continues, and I appreciate all the help that I've gotten from everybody. No hindrances. Yes, you'd look. No, the public can no longer speak. Those rules have changed.
Well, since I am representing the public here, if only because I'm here.
Name and address.
Bree Hitkevich. I live on Munson Street. My
Yes.
husband and I retired here in May, but we've had a home in Rehoboth for 30 years. First off, I want to thank you all for your service and for protecting our city by the law. That's really important. I agree with you, Mr. Strange, that there's real concerns about the administrative variance that may happen. But I'd also like to reinforce what you said, Mr. Mellon, about the environmentally, socially conscious effort to do what we do with these houses. My husband and I actually disassembled a house. We brought in a company from Baltimore. They hired people who have trouble getting jobs. They're typically people who have left prison. They're highly trained and they're very responsible. My neighbor, who is a very critical person, knows what's right, watched them take the house apart, and she was entirely pleased with how it went. We contributed our recycled, repurposable materials to the Habitat for Humanity of Sussex County. We did have Habitat come in advance of that to take out the cabinets and the appliances and all the things that they could repurpose, but they typically don't take the house apart. This house became a pile of reusable wood, actually better wood than you can buy in your home centers nowadays. And at the same time, people had jobs and self-respect. And we didn't fill a landfill. So I really do hope that you all take that kind of initiative into account, because I think it is a significant improvement to our city to be able to do something like that. That's my piece. Thank you for letting me say it. And
Thank
again,
you.
thank you for your service.
Thank
Can I
you for
pose a
what you did.
question? What was the differential between if you had it just demoed and hauled away versus what you did? Was it a significant or insignificant?
Financially, you mean?
Yeah.
It's not a straight situation. But to your concern, Mr. Mellon, that whether it delays the process, it didn't delay the process. In fact, they came in like the end of December and it was done by the beginning of January. It wasn't weeks. It was like less than a week. Financially, it's a little bit not as clear cut. You do pay for the demolition. You do pay, in our case, details out of Baltimore. They're a nonprofit that manages this. They run a repurposed
The
store.
Second Chance? Was it Second Chance?
Second Chance is another organization. Actually, when we were demolishing our house, Second Chance was doing another house on our street. But
That's the one that's doing it on Scarborough now.
Is it? Okay.
Yeah,
I think
so.
they're essentially the same
Yeah,
model.
Yeah.
Right.
But you do pay for that. You do pay for an appraisal of what's repurposable, but it does offer a tax advantage. I won't say that it would make a difference to everyone, but it was a significant tax advantage to us. But our big purpose in doing it was the concept of putting our beloved, second home with its one bathroom and its 2 bedrooms into a landfill was just unconscionable. And being able to donate it to Habitat, they don't have the resources to do what Details or Second Chance do. But in the process, it made the whole notion of losing our beloved little house a lot more meaningful. And we put too much stuff in landfills nowadays. We're all going to live on landfills in no time at all. So thank you for bringing that up. I do appreciate that. And again, continue to do good by our city. It deserves it.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you for coming.
Glenn, thank you for all the help over the years.
Same-
Sometimes hindrances, but that's all right.
Same
Few
back.
of those.
That's right. We've had our moments, but I will say that I never questioned anybody up here's dedication. I mean, if you're not dedicated, you shouldn't be on this board because you put some real hours in, and you've been one of the best. So we're gonna miss you guys. So,
Thanks.
but don't be gone though.
Thank you for all the help.
Thank you, Mr. Chairman, and it's like Glenn said, I have learned a lot. I went to school to get educated, but my learning has been here.
And we'll deal with you later. Ann reminds me of during my career at DuPont, we had a secretary, her name happened to be Irma, and this goes back many, many years ago. But you would go to Irma, just as we do with Ann, and say, this is what I want to do. And there'd be a cock of the head, and the eyes would roll a little bit, and it was like, you can't do that. That's not the way things are done. And I learned from Irma, and I've learned from Ann that to listen, that she knows. And sometimes you take her document, and you've written it out. Of course, in those days, we used to either write them out, or there were actually people that took shorthand, believe it or not. And the document comes back different than you write, and she edits it. it comes out better. Thank you for all the help, Ann. I know you're going to tell us it's your job, but it's, it is, it goes beyond that.
That's right.
Thank you. Mr. Flood, you got anything to say? Or you'll just write something? No, he's just shaking his head. He's just shaking his head. In which case, we'll take a motion to adjourn.
Make such a motion.
Second.
All in favor, say aye.
Aye.
I need a supermajority.
I think
I
we
vote
got it.
aye. Thank you.